This video is for informational purposes only and should not be relied upon as legal advice. Did you know that when people are searching for housing, there are laws that can protect them from discrimination? Knowing the law helps tenants protect themselves from discrimination and helps landlords avoid potential legal headaches. The Federal Fair Housing Act was adopted in 1968 to protect individuals and families from discrimination when attempting to access housing. The Fair Housing Act and its amendments established 7 protected classes to prevent housing discrimination, including race, color, religion, sex, handicap, familial status, and national origin. State and local governments may also create additional protected classes specific to the populations they serve. So check to see if your state or city has any additional protected classes. Landlords don't always intend to discriminate, though some do, and there are some ways discrimination can happen that aren't always obvious. Here are some examples of not so obvious discrimination for tenants and landlords to be aware of. Example 1. Rules specifically preventing children from doing particular actions such as riding a bike on the sidewalk. Children are a part of the protected class familial status and therefore cannot be treated differently than anyone else. These types of rules either need to apply to everyone or no one at all. Example 2. Landlords asking how many children a prospective tenant has, or if a prospective tenant is pregnant. While these questions are most likely asked with the best of intentions, landlords cannot treat anyone differently depending on the number of children they currently have or will have. Example 3. If a landlord denies a prospective tenant housing for any other reason than their stated qualification criteria, it is most likely a fair housing violation. The best way to avoid discrimination as a landlord is to have specific criteria every prospective tenant is held to and stick to it. Tenants should also, if denied housing, ask for the reason why and see if they are within the stated guidelines. Example 4. Landlords must accommodate, within reason, any disabilities a potential resident may have. A landlord may need to reserve an accessible space for a tenant, regardless of the number of handicap parking already in existence. Accommodations for people with disabilities also may include allowing service or emotional support animals, even if pets are not permitted on the property. Example 5. Steering is when a property manager, landlord, or real estate agent directs renters toward or away from a particular area or property based upon protected classes in the Fair Housing Act, such as race, familial status, or nationality. Steering can sound like, "You would be very comfortable here. There are many other Chinese families in this neighborhood." The best way to make sure you're treated fairly when searching for housing as a tenant or avoid legal headaches as a landlord is to know the laws that apply to you. This video is for informational purposes only and should not be relied upon as legal advice. Housing for Hoosiers is a service of South Central Indiana Housing Opportunities. SCIHO is dedicated to expanding housing options for low and moderate income households in South Central Indiana. For more great resources for renters, landlords, and property managers, visit us at housingforhoosiers.org.